We are privileged today to meet Advocate Njenga in his offices in Nairobi, Kenya. Mr. Njenga Mwangi is an advocate of the High Court of Kenya, experienced lawyer in international law. He is licensed to practice at the International Criminal Court in The Hague. He is therefore in a position to enlighten our viewers on the ongoing process in the Kenya cases. Now I'm thinking the cases now seen by many as collapsing cases after the chief prosecutor came out in the open with an outcry requesting the judges for time to hunt for new witnesses. Mr. Njenga, in your commentary on Bensouda's statement of 19th December 2013 justifying her application for the adjournment of the hearing of the case against President Kenyatta after the withdrawal of a key witness and confirmation that another witness had confessed to giving false evidence regarding a critical event in the prosecution's case. You are criticizing the prosecution for asking for time to look for new witnesses, more evidence, etc. Can you elaborate on this to our viewers, please?
Thank you, Mr. Correal. One thing I would say is that it did not surprise me that the prosecutor asked for more time to do more investigations, because those people who have been following the trials of both President Kenyatta and Deputy President Ruto at The Hague, we have all come to the one conclusion, is that the prosecutor did a shoddy job in investigating the crimes alleged to have been committed by the two during the post-election violence period in Kenya. And if we went right from the start, you will find that when the prosecutor went to the pre-trial chamber to ask for permission to investigate, you find the decision allowing him to investigate was allowed by two judges, and one was opposed to the investigation because he was of the view that the crimes that had been committed in Kenya are, in his view, wholly under the criminal justice system of Kenya. And it is the Kenyan government that should have investigated and prosecuted. When finally he got the summons against the Ocampo 6, and the cases went for confirmation of charges hearing, again you will find that the court was not unanimous in its decision in both cases, and that the decision to confirm the charges was on evidence that to the whole world was not sufficient. The Rome Statute is very clear that the pre-trial chamber acts as a sieve, so that what it decides which cases should go for trial and which cases should not.
But we know these cases are already decided.
Yes, now
that the cases are there.
I was going to the genesis of that to show that the confirmation of those charges in the first place was not by unanimous decision, and that there were serious flaws in the confirmation of those charges. Particularly now, if we come to the specific case of the President Uhuru Kenyatta, you find that they relied heavily on the three witnesses. That was witness number 4, witness number 11, and witness number 12. Witness number 4 was later proved to have given false evidence about meetings held in State House and meetings held at Nairobi Club. Subsequent to him confessing that he lied before in his statements, Mudhaura's case was withdrawn. But the prosecution insisted they still had evidence against President Kenyatta because there was witness number 11 and number 12. Now, witness number 11 and 12 have both come to say that the evidence they gave the prosecutor was based on lies.
And now the prosecutor wants to look for new witnesses, and you are You disagree with her? Why?
I disagree.
Why?
First of all, I'm saying she has asked for further adjournment of the case for another period of 3 months. This case was scheduled to start on February 5th. He has asked for further time because he says that the evidence after the withdrawal of these 2 witnesses and the confirmation that they lied in their evidence, then he says that the case as it stands today, he does not have sufficient evidence to proceed to trial. That's an admission that he does not have a case.
But as a lawyer, you're a lawyer. As a lawyer, what should you do if a lawyer stands there? I have no sufficient evidence.
In fact,
what is that? What does that tell the common man?
In the normal jurisdiction, common law jurisdiction, the case would have been thrown out by the court immediately. Because in the common law jurisdiction, you don't take the case to court and then go looking for evidence. You only go to court once you have sufficient evidence to secure a conviction. Under the Rome statute, the prosecutor is given a leeway. He can continue doing investigations even after the confirmation of charges.
Do you think there's prestige in this case?
There is absolutely no prestige. And the worst part of it is that when you look at these 3 witnesses that were used to confirm the Muthaura Uhuru cases, these 3 witnesses, witness number 4 was bringing in the connection between Uhuru and Muthaura and probably Mwangi.
I'll cut you short there
Yes.
first, Mr. Njenga. I asked if you think there's prestige in this, you said no. I'm thinking about the prosecutor. If the prosecutor knows there's no sufficient evidence, is she saving face by asking for these more months rather than say the case is dead?
I did an article in the Daily Nation of the 21st of December, and in this article, I have analyzed all the evidence from the beginning. And I've come to the conclusion that if the prosecutor, if the case against Muthaura has been dropped because the only connection connecting Muthaura and the Mungiki and Uhuru was witness number 4, once he withdrew his evidence, Muthaura's case collapsed. The prosecution insisted that it has witness number 11 and 12 who are corroborating the evidence of witness number 4, and therefore they still have a case against Uhuru. If these 2 evidence is no longer tenable and will not be produced before the court or before the trial chamber, and these 3, the 3 are the ones who are used to confirm Uhuru's case, then it means that without those 3 witnesses, Uhuru's case would never have confirmed, and therefore the most honorable thing for the prosecutor to do is to withdraw
Your independent,
that case.
your independent opinion, what do you think this case, or rather where do you think it will lead, specifically Mr. Kenyatta's case?
I think Mr. Kenyatta's case, I think Bensouda is looking for a soft spot to land, yeah? And I think eventually by the end of this month, when they go for the confirmation of charge, or when they go for the status conference, at the end of this month, I have no doubt in my mind that the prosecutor will be applying to withdraw charges against Mr. Kenyatta on the basis that he asked for time to look for further evidence. Further evidence from where if he didn't have it? Which evidence is he going to get 6 years after the case was confirmed for hearing that he couldn't have gotten all along? Is he going to shop for more witnesses who will give evidence? False evidence?
Because it can be attractive now for people to offer.
It is. In fact, if you looked at the application by the president for permanent stay of proceedings in his case, that is part of the allegations. He says the evidence produced was procured through illegal means, was fabricated, and therefore the case should be dismissed because the prosecutor had used underhand tactics in getting the charges confirmed. One of them was witness number 4. He had already confirmed to the prosecutor with an affidavit that he had lied, that he was never in State House on 26th of November, and he was never in Nairobi Club on the 3rd of January 2008. He had confirmed that to the prosecution, but the prosecution sought to withhold that evidence from the defense team went to one judge in the pretrial chamber and asked that that evidence be suppressed because it would show or it could lead to the witnesses' whereabouts being disclosed. That was not really true because there is the process of reduction which is allowed by the International Criminal Court. That could have been done without disclosing. But specifically, that witness had confessed to the prosecution that he was never in State House, he was never in Nairobi. But the prosecution went ahead and used that evidence to confirm the charges.
If we allow our, especially those who have been following the case, if we allow our intelligence to guide us to believe that Kenyatta's case, Mr. Kenyatta's case, is collapsing or has collapsed, seen from the way the chief prosecutor is now out, like I said earlier, in the open, that there's no evidence against him. What happens from your own point of view when you look at the Deputy President, Mr. Ruto's case? Because these cases are, they stem from the same report, Waki Commission. What is happening here? How these cases, many people saw they were inseparable. Now, when one hand dies, can we leave the other hand?
I will say this for sure. When Ocampo came to meet President Kenyatta, President Mwai Kibaki and former Prime Minister Raila Odinga to ask them to self-refer the Kenyan cases to the ICC, they both said no. We are in a position to investigate and prosecute these cases here. So Kenya refused to self-refer those cases to the ICC. If you notice, the same day is the same day that Ocampo filed the application seeking the court's permission to investigate, because Kenya refused to self-refer. In that application, anybody who would look at it, and those are public documents, Ocampo says that he's going to rely in his application on the evidence of certain reports, public reports. And he specifically said the report by the Kenya National Human Rights Commission, Kenya Human Rights Commission, Human Rights Watch, and the Waki Commission. He put in the document, he says, this is what I'm going to rely on. And when you, with the wisdom of hindsight, he never carried out any further investigation. Because, for example, during the confirmation of Ruto's hearing, there was an allegation that I&M Bank House, across the street from here, is owned by Emo Foundation. A prosecutor who has done due diligence should have known that I&M Bank is not owned by Emo. And who owns it? Simple background checkups. The last time I was at the ICC during Ruto's case, one witness says that Ruto made remarks about the eviction of Kikuyus from the North Rift. He claimed that case, that in a rally held at 64 Stadium in Eldoret, Ruto, in the company of Raila, talked about Madoadoa and how Kikuyus should be evicted, only to be confronted with evidence that actually that rally took place at Huruma grounds in Eldoret. That witness had already given detailed information about the shelter where the dignitaries were sitting in 64 Stadium, but when confronted with the video showing that it was in Huruma grounds, who would not see that witness is lying? And throughout the trial of Deputy President Ruto, all those witnesses, even if some of the evidence has been given in camera, the one that has been brought to the public domain shows that all of them, they've been coached, all they give fabricated evidence against the Deputy President.
Let us move quickly to a few more questions. With the new amendments, one would have expected that the Deputy President was, not to travel to The Hague for the opening of his case this year. Is the court ignoring the assembly of state parties and the adoption of the new amendments done in November last year?
In November last year, during the state parties conference at in The Hague, there were certain amendments that were made. And one of the amendments that was made was that where the accused person carries out certain state duties or state functions that are of such a significant value that he is required not to be arbitrary but to be performing these duties, then the court, on the application of the accused person, will excuse him from physically being present at the ICC seat in The Hague and to be represented by his advocate as long as he waives his right to be in that court. Ruto's defense counsel has applied and the court has declined. But literally speaking, the court has not considered that application. What it said is that the application was presented late and therefore the deputy president should present himself. Initially it was the 13th, but now I'm saying that the court has pushed it back to the 16th of January. But when the court considers that application, it has no choice, in my opinion, but to excuse the deputy president who has got enormous state functions and duties to carry out well in this country. He does not need to be seated in that court. His presence in that court does not add any value to the proceedings taking place there.
So are we maybe seeing something here happening? Because I'm seeing this Kenyan newspaper today saying it was to be 13th. It
Yes.
has been postponed now to 16th. And maybe the court wants time to look at that application which was sent in
It
late.
is very possible.
And they may excuse him also from going next week.
If that could be a possibility, or I would not be surprised if even when he goes on the 16th for the prosecution to say it has no witnesses and would want further adjournment. Notice, during the state parties conference, Ruto had been given permission to come back to Kenya. While he was in Kenya, Bensouda made an urgent application asking that Ruto be forced to appear there because she has evidence that Ruto will be leading a delegation to the state parties, which was a lie. Immediately Ruto appeared in the ICC for the hearing. They asked for an adjournment. Hello. My question is, a prosecutor of the caliber of Bensouda should line his witnesses for the whole duration of the timetable of the court. She cannot be heard to say, stop, after 3 days, stop, let's go look for another witness, or this witness did not have time to travel. All it's confirming is the shambles in the prosecution case, and I have no doubt in my mind that both these cases are collapsing, and they are on what I call in my article a self-destruct mode.
A short and final question because of time. Now that it seems Mr. Kenyatta's case is going nowhere, and if Mr. Ruto's case was to continue, is there any danger in the running of the Jubilee government, which we all know has been successfully formed by the two gentlemen, and really they seem to be serious in their job to lead Kenya?
Let me say this.
Let us end with that.
I've said this before, that these cases, what they've done is that they've continued to take time away from the president and the deputy president in managing the affairs of the state and reconciling this country. And it is time these cases were brought to an end so that this country can move forward.
Mr. Njenga Mwangi, thank you for enlightening our viewers today.
Thank you, Mr. Correa.